To call the Law Amendments Committee to order. In the absence of the chair and the vice chair, it falls to the committee to choose a chair for the meeting today. I'd look for a motion from one of the members. Ms. Lones-Cross.
I'd like to make a motion. I move that Patricia Arab serve as chair for the meeting.
Thank you. Any comment? Mr. Johns? No, we don't need a seconder. All those in favor of the motion? Opposed? Ms. Arab will take the chair.
Good afternoon, everyone. My name is Patricia Arab, and I'm the MLA for Fairview Clayton Park. And we will begin the session of our Law Amendments Committee by having the members introduce themselves, starting with Mr. Jesson.
Thank you, Madam Chair. I'm Ben Jesson. I represent the community of Hammonds Plains, Lucasville.
Tony Ince. I'm the MLA for Cole Harbour, Portland Valley.
Good afternoon. I'm MLA Suzanne Lones-Croft, Lunenburg.
Good afternoon, everyone. Brendan McGuire, Halifax Atlantic.
Good afternoon. Claudia Chender, MLA for Dartmouth South.
Hi, I'm Gary Burrell. I represent Halifax Chebucto.
MLA Brad John, Sackville Beaverbank.
Bonjour et bienvenue. My name is Chris Antoine, the MLA for Argyle Barrington.
Thank you, everyone. Now, we have three bills to discuss today that have representation, and 6 that have been brought back. No, my apologies. 2 that were brought back and 4 with no representation. So we'll start with Bill 32, the Body Armor Control Act, and I ask that Superintendent Brenda Young please come to the mic.
Good afternoon, everybody. My name is Superintendent Brenda Young, and I'm the officer in charge of the Administration Division with Halifax Regional Police. As a member of the executive of the Nova Scotia Association of Chiefs of Police, I am here today representing our President, Deputy Chief Robin McNeil, and all other municipal police agencies in the province of Nova Scotia when we reiterate our support for the Body Armor Control Act. This is an extremely important piece of legislation for law enforcement in the province, and it comes down to the safety of first responders and the public. We know that members of organized crime, especially members of outlaw motorcycle gangs, as well as others engaged in criminal activity, are in possession of body armor for the sole purpose of protecting themselves in violent confrontations with the police and with each other. The possession of body armor gives these individuals a false sense of security, and it will make them more brazen in the way that they commit their crime. And this puts law enforcement and members of the general public at risk. Over the past several years, we have seen an increase in the incidence of body armor amongst the criminal element. Nova Scotia Chiefs of Police takes the position that the only reason to be in possession of body armor, other than for a bona fide requirement like law enforcement, is to engage in criminal activity. Placing restrictions on those who can possess body armor and arming law enforcement with the ability to seize body armor from those not authorized to possess it will assist us in keeping the citizens that we serve safe. I want to thank you for your time and consideration of this very important piece of legislation that's focused on the safety of first responders and the public. And if there's any questions, I'd be happy to answer any questions you have.
Thank you, Superintendent Young. Do we have any questions?
No.
Thank you very much.
Thank you.
If I could have Richard Doyle please come up. Mr. Doyle, if you could just let us know who you're here representing.
Sure. My name is Richard Doyle, and I'd like to thank you very much for the opportunity to speak here today. It's very near and dear to my heart, so I appreciate this opportunity. And please bear with me because public speaking probably isn't one of my greatest strengths, so I'll do the best I can to speak my mind for you today. Like I said, my name is Richard Doyle. I am a provincial civil constable, licensed under Section 3 of the Police Services Act. I'm also the owner of a company called 5 Star Bailiff and Civil Enforcement Services. We currently service Nova Scotia, New Brunswick, and Prince Edward Island. And before I go any further, excuse me, I think I should explain exactly what a bailiff is because we get asked that on a daily basis. The legal definition, I'm not even going to talk about that. Basically what we are the repo men. A lot of people confuse us with what they see on People's Court, which is the American bailiffs. But Nova Scotia currently is one of the few provinces that has an unregulated bailiff service. So there's no regulations in any of our legislation for bailiffs to follow. A number of years ago, I started my bailiff company, and I kind of modeled it after what I had seen in Alberta, Ontario, etc. Kind of what I wanted to do was bring a sense of professionalism to the industry. Most repo guys or process servers walk around in jeans and a t-shirt, lots of muscles and tattoos. The only thing I guess I have are tattoos. So what I wanted to introduce to it was to follow what the Bailiff Acts outlined in other provinces, and to present ourselves in a very professional manner. It is an extremely difficult and dangerous job. It's often said that we do everything that a police officer does without a gun. And to put that into perspective for you, quite often we are dealing with people on their worst day, whether it be serving them a document, that a court document, an eviction document. We deal with things like emotional and mental issues, drug addiction. Really, we're seeing people at their lowest point. It's very unpredictable. It's very dangerous. As an employer, I have taken every step that I can to protect the people that work for me. For instance, they receive the best use of force training that is currently offered, tactical handcuffing, and they receive the best self-defense training that can possibly be provided. That's done simply to protect themselves. At any given moment, we do not know what we're walking into. It could be as simple as serving a document to a door. We have no idea of the level of a hostility or aggression that's going to come out of that door at us at any given moment. Fast forward to something like repoing a car, where we have no idea how a homeowner is going to react when they see us in their yard attempting to seize their personal possessions. Like I say, it is a very dangerous job, a very unpredictable job. I spare no expense at any point to make sure that my bailiffs are as trained as they possibly can to handle any situation. We receive verbal, physical threats on a weekly basis. We are often stalked after the fact and threatened. It is really one of the most difficult jobs that there is to do, but someone has to do it. My approach on it has been to give it the most professional approach that I possibly can. All of my bailiffs wear a uniform. They currently do wear a body armor. it would be a very unfortunate situation if they had to remove that. They are certainly put in those vulnerable positions at all times. So as an employer, I would feel much more comfortable if there was something allowed in the legislation. And I'm not speaking for the bailiff industry. I'm only speaking for my company. And my company goes to the ends to try to make sure that they are safe at all time. I guess what I would ask for is if a company could apply for a permit to have their people covered for any given situation. And to put that in perspective, my office manager is a 48-year-old female that I sent to a 1-week self-defense class, because we never know what these people are going to do and how they're going to react to it. And trust me, the threat is real sometimes to us. On a number of occasions this year, we had to call police for backup because the situation had escalated to a point that one of my staff members was in harm's way. A lot of times we're in the middle of nowhere at different days or different times of the evening or the night. And we must take every precaution that we possibly have. Anything like body armor that could help one of my people in one of those dangerous situations, I must come here today and fight for that opportunity. I would just like to finish up by saying that we work with law enforcement as closely as we possibly can. Although we're not a paid government agency, we are civilians. I am a member of the board of directors to the Civil Constables Association of Nova Scotia. They have a code of conduct, which I personally follow, and my company has been designed to follow it the same way. So when I say that I would like the ability to apply for a company permit, these are the type of things that I would include in my application: the code of ethics that my company does follow, the training that my bailiffs go through to work for me, and all of the certifications that I make them get that is not regulated to get, but is really in their best interest and safety to have. So that's all I would throw out there. I can open it up to any questions you may have.
Great, thank you very much, and thank you for your service.
Thank you.
Mr. Johns.
Thank you, Madam Chair. Just out of curiosity, do you do any sub work for any municipal units, bylaw services, police department, or provincial department at all? Like whether it's serving something or anything like that?
On a regular basis, we would serve hundreds of documents in the run of a month. So that could go anywhere from the residential tenancy notices to small claims and Supreme Court documents. As well, this year, I have been I say appointed, but designated by both the Small Claims Court and the Supreme Court as a small S sheriff. And when I say a small F sheriff, then the court order is written out that Provincial Civil Constable Richard Doyle can act as the sheriff on that court order. So when doing that, my bailiffs will assist me in those actions. So to answer your question, yes, we are often used. In some cases as well on tenancy issues, where you could have a tenant that is very upset, very disruptive, even violent, but hasn't crossed the line that he can be arrested, but is still a potential threat as far as the other tenants or the superintendent of the building is concerned. A lot of times the local police will recommend that we come in with our knowledge of residential tenancies and just to have a presence in the building for safety and security means. Not in the capacity of a security guard, but just someone that can handle the situation properly and with the knowledge of tenancy rights.
Great.
Perfect, thank you.
Thank you. Ms. Chender.
Thank you. Thanks for coming in, and I know we had some conversation through my office earlier.
Yes.
Now, it's my understanding, and I just want to check with you, that you would be covered under the current act as a provincial civil constable. Is that correct?
Yeah, I didn't see a provincial civil constable outlined in the current legislation. I just see special constable.
So in fact, it is.
Okay.
It probably wasn't in the press release, but my
Okay.
understanding, and my colleagues in government can confirm this, is that it is. So given that that's the case, and we'll get confirmation on that, would you still be looking for bailiffs in general to be named specifically, or would it be the section reads that a provincial civil constable appointed under the Police Services Act, which you are, and whose appointment specifies the individual is authorized to possess body armor, would be exempted basically from this act, which says that no other person would. Is that sufficient for you, or would you need more than that?
It is fine. What I was looking for is the ability to have myself or my company have the authority to issue body armor to employees of mine when I feel that it's required for their job. Now, these individuals would be in uniform at all times when working, and that would be the only time that they would have the body armor on. What I didn't want to get into was having my bailiffs have to get their provincial civil constable's license, and that's for a number of reasons. First of all, although anybody can walk in and apply for that right, to work for me in my organization, I take it to a different level. Matter of fact, other provincial civil constables quite often call me for my input on regulations and law. So I have a process that I put my individuals through until I feel that they have enough training to go for their appointment. Now, that's a standard that I have set within my company. So over their first year of employment, they are required to go through a number of training courses, which I feel are relevant to do their job properly and professionally. And if they get through that year and have completed all of that certification, then I allow them to go for their constable license. That being said, there are a number of restrictions to becoming a provincial civil constable as well that can hold people up.
Okay, thank you.
Mr. Doyle, if you'll entertain a question from me, I'm just curious if other private companies follow the same rigorous standards that you follow for your employees.
I am the only one, to my knowledge, that sets these standards, and the success of my company depends on our reputation out there. So there's no other company in Atlantic Canada, to my knowledge, that sets its standards where we do. That's why we've expanded from Nova Scotia into New Brunswick and Prince Edward Island as well, because we deal with a lot of companies that are based out of Ontario that have a Bailiff Act, and they're used to a certain standard of professionalism. They know when they call ours that we are meeting and exceeding that.
Wonderful. Thank you. Thank you very much. Any further questions? Okay. Thank you.
Thank you very much for the opportunity today. It's greatly appreciated. Thank you, sir.
Do we have a motion from the floor? Mr. Jessam.
That, excuse me. Thank you. I move that Bill 32, the Body Armor Control Act, be moved back to the House without amendment.
Could all those in favor signify by voting yea? Aye. Any opposed? Thank you. That bill is returned back to the floor of the legislature. We'll move on to Bill 38, the Residential Tenancies Act, which has been amended, and I believe every member has copies of that bill in front of them. And we have Kevin Russell. Mr. Russell, if you wouldn't mind stating which organization you're here representing?
Yes, Madam Chair. I'm here representing IPONS, the Investment Property Owners Association of Nova Scotia. Thank you. And IPON members represent 46,000 apartment units in Nova Scotia. According to a 2015 KPMG study, the multi-unit residential industry contributes $1.7 billion to Nova Scotia's GDP. IPONS is pleased with the government's decision to go where previous governments have failed to go, the modernization of the RTA, the Residential Tenancies Act. The act in its current form is regressive and negatively impacts both landlords and the 300,000 Nova Scotians who have chosen their home to be in a rental environment. IPON's expectation is for this government and successful governments to go beyond these initial steps taken in Bill 38 and continue to modernize the RTA to improve operations for landlords and the lives of Nova Scotian renters. IPONS is appreciative of government's attempts to introduce alternative document deliveries. There is, however, concern with the alternative document or delivery options for director documents. Service of Documents Clause 15.2 reads, service of all documents except documents relating to application to the director under Section 13 and documents relating to an appeal to the Small Claims Court must be served by a landlord or a tenant. Landlords must have the ability to deliver application to director documents in the same manner prescribed in other documents in Clause 13.15.1 to ensure documents are and can be delivered in a timely manner. It should be noted the placing of director documents in a tenant's mailbox, as noted as an alternative delivery method, is not an option for landlords. For the majority of buildings' mailboxes have crown locks, meaning only Canada Post personnel can access the mailboxes. So no staff or a company other than Canada Post can insert documents into a mailbox. Landlord's preference is to replace the mailbox option with having the ability to post director documents in a conspicuous place as an alternative delivery option. In addition, the ability to serve documents by email is by far the preference for alternative delivery, which is not being proposed in the current amendment for director documents being delivered. Widening the alternative delivery options to include posting and email aligns with provincial RTAs in Ontario, Alberta, Manitoba, and Saskatchewan. IPONS is appreciative of the government's decision to tighten guarantor agreements. However, IPONS cannot agree with proposed amendments in Clause 5 and 8K2. Clause 5 reads, a guarantor must terminate a guarantee agreement upon receipt of a notice of a rental increase by providing written notice to the landlord at least 3 months before the effective date of the rental increase by a method of service provided in Section 8D. Clause 8K2 reads, where the landlord consents to a subletting, the guarantor has no obligation under the guarantee agreement for the duration that subletting unless the guarantor enters into a written agreement or guarantee agreement with the landlord that is specific to that sublet. Given that these clauses are associated with other clauses within the Act, IPONS consider these clauses ambiguous and as such could be misinterpreted by all parties, including landlords, tenants, residential hearing officers, and small claims court adjudicators. IPON's request is that have these clauses looked into at more detail to find ways to clarify interpretation to ensure clauses are applied fairly. In addition, these clauses have potential to negatively impact first-time renters and students' ability to rent. Landlords will have to assess the risks associated with these clauses, and if uncomfortable with associated risks, a landlord might decide not to rent to renters requiring a guarantor, or instead of offering a 12-month periodic lease, offer 12 months fixed-term leases that automatically terminate on a lease expiry date. Fixed-term leases will result in tenants having to move out on the lease expiry date or be confronted with signing a new fixed-term lease with a qualified guarantor. IPONS is appreciative for reducing abandoned property holding requirements from 60 days to 30 days. IPON's preference, to further this, I think we'd like to see it strengthened that IPON's preference for Nova Scotia to follow the lead of Newfoundland and Manitoba and defining classifications for abandoned property. For example, in Manitoba, a landlord may decide that the items have limited monetary value. This means that if the items were sold, the sale proceeds would not cover the cost of moving, storing, or selling them. And in this case, the landlord must make reasonable effort to contact the tenant about picking up their property. The landlord must also list the items on a form. Once the landlord completes the form, they send it to the residential tenancies. The landlord must also send a copy to the tenant at the last known address, and this may even be the address of the rental unit. Once the landlord has done this, they can give the items to a charitable organization or dispose of them at an appropriate disposal facility. And if a landlord believes the items have no monetary value or are unsanitary or unsafe to store, the landlord may dispose of them without authorization from the residential tenancies, with one exception. If a tenant leaves personal papers or photographs, the landlord must hold them for 60 days before disposing of them. The landlord must also complete the inventory form and send it to the residential tenancies and the tenant. In closing, annually there are an estimated 5,000 director applications, or in other words, 4.5% of the province's 110,000 rental units are negatively impacting landlords' operational costs, which in turn are passed on to tenants through higher rent. And it's interesting, between 85 and 90% of the applications filed are for non-payment of rent. So instead of penalizing, isn't it time for government to begin rewarding professional landlords who obey the rules and regulations in Nova Scotians living in the 105,000 rental units who pay their rent on time and obey these rules? Conversations during consultations revealed the gap between stakeholders' positions is not insurmountable. Therefore, modernizing the Act, the RTA, is doable. And there is consensus maintaining the status quo is unacceptable, unsustainable, and unfair. The multi-unit residential industry has matured to where there is recognition problems being experienced with a minority group of landlords and tenants. Therefore, to meet the demands of today's rental market, there is an urgency to completing the modernization of the RTA to reward those who play by the rules. And thank you for allowing me to speak today.
Thank you, Mr. Russell. And I'm wondering if perhaps you could provide a copy of your remarks to our page so that we can copy it and ensure that the members have them.
It's a little scribbled.
Scribble's all right. Do we have any questions from the floor? Okay, thank you very much for your time. I appreciate it.
Thank you very much.
So as stated earlier and on our order sheet, this has an amendment that is being recommended to our committee by the Minister of Service Nova Scotia. And we'll have the clerks passing it around. So I think everybody has a copy now. For the sake of the audience, I'll read the change, the recommended change. It's on page 10, subclause 11, section 4, proposed subsection 13, 2A, line 1. It's deleting the word may and substituting with the word must. Ms. Lonescroft.
May we take a short recess?
No problem at all. Yeah.
To concur.
We'll recess for 3 minutes. Okay, if I could bring the committee back to order, please, and have all of our members back in their seats. If we could have all members back. So we do have an amendment. Do we have a motion? If I could ask everyone in the audience to quiet down, I'd appreciate it. I'm sorry, we are trying to transcribe this as well, so as little noise, background noise as possible would be appreciated. Mr. Jessam.
Madam Chair, through you to the members of the committee, thank you for your patience and indulgence. As per the paper that we have in our hand now, I'm referencing LAC Gov-1, and I move the following amendment. Page 10, subclause 11, sub 4, proposed subsection 13, 2A, line 1, delete, quote, may, and substitute, quote, must. So moved.
We have a motion. Could all those in favor please signify by saying yay? Aye. Aye. Any opposed? The amendment is carried. Any further motions? Mr. Jessam.
Thank you, Madam Chair. Through you, I move that Bill 38, the Residential Tenancies Act amended, be moved back to the House with that single amendment. So moved.
Could all those in favor signify by saying aye? Aye. Contrary-minded, nay? Bill 38 will be returned back to the House as amended. We'll move on to Bill number 39, the Cemetery and Funeral Services Act amended, and Embalmers and Funeral Directors Act amended. And we have one speaker, Mr. Gary Bennett. If we could have Mr. Bennett come to the front.
Thank you for having me here today.
Thank you, Mr. Bennett, for being with us.
My wife passed away in December. The funeral was on the 28th, and they mistakenly cremated her. And my experience with the funeral home directors wasn't all that good. And I just hope that you'd consider changing this amendment that's in.
Thank you, Mr.
I'm not
Bennett.
very good at.
That's okay. And you know, and I think I speak for everybody around the table, having lost a loved one and knowing how difficult that is,
Yes.
to have the added trauma that you had to face. I really do feel very sorry and appreciate you being finding the strength to be such a strong advocate to hopefully make sure that nobody else has to suffer through the same.
Yes. I hope nobody else does.
Thank you. Are there any questions from the members? Mr. Lohr.
Yes, Madam Chair, John Lohr, MLA for Kings North. Gary, I understand there's things that you like about this bill and things that you don't like. Can you tell me what parts of the bill that you are okay with?
Well, when the funeral home picks up a body, they have to have a wrist tag on it. The paperwork has to match. That is a good thing. But when it comes to the funeral home directors, it's still a little one-sided.
Right.
And I hope that changes.
Right. So if I could continue, I understand that you were able to make a complaint to the embalmers and funeral home directors, and you chose not to participate in that complaint process. Why did you choose not to participate in that complaint process?
There is a lawyer involved in that, and he told me it wasn't worth the time for him to go down with me to go into that meeting. You asked a few questions and then escorted out of the room, and you're not allowed to hear what the other side said.
So your main issue with this bill as it stands right now is that you can't, someone who has a complaint doesn't have the opportunity to hear both sides of the
story, no.
story, yeah.
Thank
So,
you. Are there any further questions for Mr. Bennett? Okay, thank you, Mr. Bennett.
Thank you very much.
So,
Mr.
Madam
Lohr?
Chair, I would like to move an amendment to Bill 39. I believe it's been distributed around that. I can read the whole amendment into the record if you want, if that's okay. That after Clause 9, Clause 10 states, Chapter 144 is further amended by adding immediately after Section 14 the following sections. 14A, bylaws made by the board pursuant to Section 14 shall permit the board, persons making a complaint, and persons about whom a complaint is made to A, be represented by counsel at the hearing of complaints, and B, hear and question all evidence presented. 14B, bylaws made by the board pursuant to Section 14 shall provide that A, both the person making the complaint and the person about whom the complaint is made may be present. B, the testimony of witnesses must be under oath. And C, participation by witnesses other than their examiner cross-examination is at the discretion of the chairman of the board. So I would like to move this amendment.
Okay, thank you, Mr. Lorisarni. Ms. Lonis-Croft.
We would like to stand this and send it back to the department for more consultation and to review the comments made here
So
at the
I think
meeting.
that perhaps in light of Mr. Bennett's concerns and the amendment that we have here, we will stand this bill. And so for all those in favor, please signify by saying aye. So we will defer and we will stand the bill and take a look at both Mr. Bennett's comments and concerns and this amendment. All those in favor signify by saying aye. Contrary-minded, nay. The bill is stood. Thank you. Change sheets on it. Oh, okay. So I think since we have no further witnesses for our 4 other bills, I'd like to just kind of jump and then move back to Bill 27, if that's all right with the committee. So Bill 42, the Vital Statistics Act.
Hold on. Sure we're not missing anything?
We sure can, yeah. So we'll look at Bill 29 first, the Labor Standards Code. Mr. McGuire?
29, the labor standards. Yeah.
Two pages. You guys said 2 amendments. Okay.
Mr. McGuire?
I move that Bill 45, the Senior Citizens Property Tax Rebate Act, be moved back to the House without amendment.
So the motion is that Bill 45, the Senior Citizens Property Tax Rebate Act, be moved back to the House without amendments. All those in favor, please signify by saying aye. Contrary-minded, nay. Bill 45 is referred back to the House. Mr. McGuire.
Madam Speaker, I move that Bill 48, an act to amend various statutes of the administrator by Service Nova Scotia, be moved back to the House without amendment.
So Bill 48, an act to amend various statutes administered by Service Nova Scotia, moved to back to the legislature without amendments. All those in favor, please signify by saying aye. Contrary-minded, nay. Bill 48 is returned back to the legislature.
We didn't do 44.
Mr. McGuire.
Which one? The rest have amendments. Okay, so I move that Bill 44, a Change of Name Act, be moved back to the House without amendment.
Bill 44, Change of Name Act, be referred back to the House without amendments. All those in favor, please signify by saying aye. Contrary-minded, nay. Bill 44 is returned back to the floor of the legislature. So we will go back to Bill number 27, the Animal Protection Act, with amendments. Mr. McGuire.
Madam Speaker, I move that Bill 27, the Animal Protection Act, be moved back to the House without amendments.
Mr. D'Entremont.
Thank you very much. I know there was a fair amount of consultation or a lack of consultation from the people that we had in the chamber last meeting. And I'm just wondering, I mean, I find it surprising that there was no either amendments or further discussion on maybe what the department thought or what government thinks about the bill. You know, it was my only concern. You know, when we get into tail docking, those kinds of things, you know, I agree with the bill. But when you get into the issues that were brought forward by some of the breeders, you know, it kind of made me listen. So I don't know if there was any further discussion around the consultation phase of this. But just to say, you know, if this goes forward, fine. Just hopefully that there's further discussion in the House of Assembly.
Ms. Chender.
Thank you. I guess I look forward to seeing if there's a response to my colleague's comment, but I would echo that without getting into the substance of the bill, it's clear that there were some key groups who were not consulted here. Most notably, we heard from the Canadian Kennel Club, various breeders, but also the Federation of Agriculture to talk about inspection issues. I know this bill was a long time in the making and there was a fair amount of consultation done. So I would, again, just echo the sentiment that if we took this long to get here, it's surprising to me that we're turning it back around after standing the bill down in a week without, to our knowledge, any further consultation. So I'd welcome any comments on that.
Okay. So we do have a motion on the floor. All those in favor of returning Bill 27, the Animal Protection Act, to the floor of the legislature, please signify by saying aye. Contrary-minded, nay. The Bill 27 is moved back to the floor of the legislature. Bill 29, the Labor Standards Code. I believe we have a number of amendments. Ms. Chender.
Thank you. I'd like to move an amendment. We attempted to move this last time, but it wasn't drafted, so here it is for everyone's reading pleasure. We originally brought forward this amendment because we felt that an error had been made in the drafting of this. This government's been very clear that they want to make sure that they are bringing this bill in order to comply with the federal legislation, which has recently changed on parental leave. That federal legislation specifies a longer leave period, as everyone knows, but the eligibility for that leave period is different. So in the federal regime, it's 600 hours. In this bill, as it stands before us, it's 1 year. So that has a very material impact on the ability of women to work, the ability of women to go back to work, and the ability for women to take advantage of these new expanded federal provisions. In presumably the rest of the country, as they pass their mirror legislation, after a period of 15 to 17 weeks in a position, they will be eligible to receive the parental leave. In Nova Scotia, however, if they try to take advantage of the federal framework, a woman would be at risk of losing her job. So she could collect the benefits, but she would not have job security if she had been at her job for under 1 year. We know that there are a huge number of Nova Scotians, particularly younger Nova Scotians, who do not have permanent full-time positions. That's higher than in the rest of the country, and that trend line isn't getting any better. We know that we recently saw a Labor Standards Act around unpaid leave for survivors of domestic violence. The eligibility for that is 3 months. So it's mystifying, to say the least, to us that this eligibility period would not have been brought in line Our understanding anecdotally was something about the need for consultation. I'm not exactly sure what to say about that. Of course, it is, complying with these kinds of provisions can be onerous for business owners, but this is, when we pass legislation like this, it's about the society we want to live in. It's about gender parity. It's about women being able to participate in the workforce. So I will move this amendment again with the hopes that it was indeed a mistake and that this legislation will do what we were told it was going to do, which is to mirror the terms of the federal legislation such that it can be enforced in Nova Scotia. So the amendment is found on LIC NDP 1, page 2, subclause 8, sub 1, line 2, add striking out 1 year immediately after by in the second and third lines, and substituting 17 weeks. And page 2, subclause 9, sub 1, line 2, add striking out 1 year immediately after by in the second line and substituting 17 weeks and. So that 17 weeks is just a stand-in for 600 hours. It's sort of more or less works out to that. Thank you.
No problem. Do we have any further amendments on this particular bill? So I would ask that, Ms. Lonis-Croft.
Can we take a short recess?
Yeah, that was actually my next words, that maybe we'll take a 5-minute recess to go over this particular amendment. I'll give you time for coffee this time, Mr. Donchemo. Okay, I know that wasn't 5 minutes, but we'll resume. Do we have any comments from the floor? So we have a motion for LIC NDP 1 to change, to amend Bill 29, page 2, subclause 8.1, line 2, adding strikeout 1 year immediately after by in the second and third lines and substituting 17 weeks. And page 2, subclause 9.1, line 2, add strikeout 1 year immediately after by in the second line and substituting 17 weeks and. All those in favor of the amendment, please signify by saying aye. Contrary-minded, nay. The amendment is defeated. Ms. Lonis-Croft.
I'd just like to say that the department is going to take this particular area and review more than just that in their whole labor code. So that's expected in the coming months by the spring.
Thank you, Ms. Lonis-Croft. Mr. Jessam.
I move that Bill 29, the Labor Standards Code amended, be returned to the House without amendment.
The motion is for Bill 29, the Labor Standards Code amended, be returned back to the floor of the legislature. All those in favor, please signify by stating aye. Contrary-minded, nay. Bill 29 will be moved back to the floor of the legislature. Bill 42, the Vital Statistics Act. Mr. McGuire.
That Bill 42 be put back to the House without amendments.
The motion is Bill 42, the Vital Statistics Act, be sent back to the House without amendments. All those in favor, please signify by stating aye. Contrary-minded, nay. Bill 42 will be returned back to the floor of the House. And that will conclude our committee today, I think. Oh, Mr. McGuire.
Thank you, Madam Chair. I would just like to ask Mr. Hebb if we could potentially look into a way to reduce some of this paper. There has to be, with today's technology, there has to be a better way to do this. I mean, this is hundreds and hundreds of pieces of paper that every member here got. It seems to be a bit wasteful. So I'm wondering if there is any way the committee can look into potentially practices that other committees are doing, or find a way to reduce some of this paper that we're using.
So thank you, Mr. McGuire. We'll leave that with the clerk's office and with our committee's office and see what we can come up with. Right, Michael? Not funny. Thank you. Thanks to all the members, thanks to those in the audience and our staff members, and that concludes our committee for today.